She reached up to the sky of stars and caught the red-hot light of the North Star.
Good afternoon and welcome back. Last week, Leonard Peltier, a member of the Turtle Mountain Band of Chippewa Indians, crossed the Turtle Mountain Indian Reservation line with a raised fist. The 80-year-old Native American activist who had been imprisoned for nearly 50 years, wrongly convicted and connected with the murders of two FBI agents, waved to his sisters among the sea of supporters waiting in sub-zero temperatures to welcome him home. Who is he? How is he? Why was he imprisoned? And why did it take so long to get him released? Let's connect some dots and find out.
Connecting the Dots with Dr. Wilmer Leon, where the analysis of politics, culture, and history converge.
Welcome to the Connecting the Dots podcast with Dr. Wilmer Leon, and I am Wilmer Leon. Here's the point. We have a tendency to view current events as though they take place in a vacuum, failing to understand the broader historical context in which they occur. During each episode, my guests and I have probing, provocative, and in-depth discussions that connect the dots between these events and the broader historic context in which they take place, thus enabling you to better understand and analyze these events that are impacting the global village in which we live. On today's episode, the issue before us is, for most of my life, Indigenous activist Leonard Peltier has been in prison. He was active in the American Indian movement, which has grappled with police brutality and discrimination against Native Americans since the 1960s. Now, he has returned home nearly half a century after he was imprisoned for the 1975 killings of two FBI agents, Jack Kohler and Ronald Williams, at the Pine Ridge Reservation. President Joe Biden commuted Peltier's sentence following decades of community-led advocacy, calling his imprisonment an example of the U.S. government's mistreatment of Native Americans. For further insight into this, we are joined by the lead member of Leonard Peltier's legal team, attorney Jenipher Jones, founder and managing attorney of the law firm For the People. Attorney Jones, welcome to the show.
Thank you for having me today, Dr. Leon. It is really just such an honor. Thank you.
So tell us, first of all, two things. One, who is Leonard Peltier and how is he doing?
Well, Leonard Peltier is or was the longest serving Indigenous political prisoner in the United States. His case over the last 50 years has gained infamy for the government misconduct that went on, really, of course, at the trial and extradition, but continued throughout his incarceration. But Leonard now, it's a little over 1 week since he's been released, and he is doing well. He's happy. He's getting medical care. He has of course, with his family and community, which is really important. And so it is almost just night and day from about a week ago. In meeting with Leonard at USP Coleman 1, where he had been in Florida. And we're just so grateful that he is on home confinement right now, and that he's doing well, that he's happy and grounded.
So please elaborate again, as I said in the open, and I think this is accurate, that President Biden, on his last day in office, commuted his sentence. Explain, he was not pardoned. The sentence was commuted. If you could explain the intricacies of that, please.
Yes, he was. There's a difference between executive clemency and a pardon. A pardon is something that Leonard wasn't eligible for and still isn't, because and it's actually something that he doesn't support right now. And I know there were many people calling for a pardon, but that's because a pardon is an implied admission of guilt. And when Leonard has, for all of these decades, insisted upon his innocence, and then also you have to be out of prison for 5 years. So he is not eligible for a pardon, but he did receive the executive clemency on the last hour of Joe Biden's administration, former President Joe Biden's administration, on January 20th. That states that he should be remanded to home confinement for the remainder of his prison term, which is a life sentence. It's indefinite.
Let me see if how I can phrase. Well, I'll just ask it this way. And I'm glad you made the point. It was the last hour of President Biden's term. Were you all surprised? Did this come out of the blue, or were there any indications from the administration prior to the notice that this was going to occur? Attorney Jones?
Okay. Can you hear me now? Okay, yes. I don't know why it went on mute. I wanted to say that I wanted to give a shout out to Robert Gifford, attorney Robert Gifford, who worked very vigorously on Leonard's executive clemency, did an amazing job. It is always a shock to receive the final word. But in many ways, I wasn't surprised. Sorry for
that. You are a busy person and a much sought after attorney. So I definitely understand. Oh, and Robert Brown, thank you for that $10 super sticker. So I think you were saying that this did not, that you're always waiting until the moment, but this did not come as a surprise.
No, not completely. It certainly was stunning, but it wasn't necessarily a surprise.
And how long have you been working on the case?
I've been working on this case for 2.5 years. And the way that the case is broken up was between executive clemency, so basically political work, and litigation and administrative strategy and advocacy, like the parole. So we've sort of switched off and supported one another as legal teams. We led Leonard's parole, putting those issues front and center.
Now, so prosecutors maintained at trial that Leonard Peltier shot both agents, Jack Kohler and Ronald Williams, in the head at point blank range. Leonard Peltier has always acknowledged being present and firing a gun at a distance, but he said he fired in self-defense and that his shots weren't the ones that killed the agents. Can you give us, as cursory as you need to, that still explains what transpired? Can you explain to the audience exactly what happened in 1975 at the Pine Ridge Reservation?
Well, what I can say is, of course, as I said before, is that Leonard has maintained his innocence. But the most important thing is that the government could not and did not make its case on legitimate grounds. Prosecutorial manager, Attorney James Reynolds, articulated that the ballistics did not match. And that was addressed on appeal. And unfortunately, that was way a long time ago, before I was even born. But I'm not sure that it was addressed appropriately by the council at that time. But the ballistics didn't match, with the gun that they say Leonard used, and the ones that that the agents were shot by and killed by, unfortunately. So the government did not meet its burden of proof. There's so much to get into about that day, but really at this point now, 50 years later, it's almost irrelevant because the way and the manner that Leonard has been incarcerated itself is unconstitutional. So that has been our focus, and there's many reasons why we have taken that tact and that approach with this case.
Well, let's get into the way and manner in which he has been incarcerated, and you say that is unconstitutional. If you could elaborate, please.
So yeah, I mean, I think what we put forth in the parole to solidify the legal posture of Leonard's case and highlighting his unlawful detention and the decades-long severe medical neglect were really important. Before I get into it, I want to let people know that Leonard's case, surprisingly, has not been heard by a court of law in over a decade. And then prior to his last parole hearing in 2024, it had not been considered, at least his parole, in a decade and a half. And we have consistently maintained that Leonard is unlawfully detained and that any detention of him is unlawful. And, we're excited at this outcome, think it's one step in the right direction. But we did look at this from a constitutional lens. And when I took his case as a constitutional practitioner and trained and having taught prisoners' rights and the Eighth Amendment to law students, I knew that for there to be this kind of legal outcome after 50 years, not just the conviction itself, not just the unfair trial, not just the sham extradition from Canada, but to have this kind of outcome, where there's absolutely no release latch, just the same denials over and over again, almost copied and pasted over the years on this kind of flimsy case, that something really went wrong, especially procedurally. Something in the operation of law had to have gone very wrong. And I sense that given the string of various denials throughout the decades. Now, whether that was by deliberate means or simply by the operation of law, I didn't know at the time, but I knew something was malfunctioning because his case bears all of the characteristics of that kind of statutory malfunction that may amount to a constitutional violation. And so indeed, I found precisely just that the U.S. Parole Commission was applying the wrong law, that they were applying a law not in effect at the time of the alleged offense. And that's an ex post facto violation because it had the effect of giving Leonard a harsher sentence than intended by the United States Congress at the time of the alleged offense. And so if you can believe it or not, that issue had never been previously identified or even raised in the previous near 5 decades at that time. But it's a problem because that statute, and Leonard is not the only one that the U.S. Parole Commission is doing this to. It's much harsher. The statute that the U.S. Parole Commission is using has the effect almost of 100% of continuing to detain Leonard and other federal old law prisoners like him, whereas the previous statute at the time of the alleged offense, as I said, had a different congressional policy objective in terms of so-called crime and punishment. And it really thematically involves a conversation of so-called pre-mass incarceration statutes versus mass incarceration statutes. The statute that the U.S. Parole Commission uses to assess Leonard's eligibility for release is a mass incarceration statute with harsh policy objectives of retributive justice, steeped in racial bias and all the things that we have come to know what mass incarceration is. And the reason that's a problem, as I've said before, is that it is harsher and it has the effect of wholly keeping him in. And there's obviously case law about this issue. And so what I took to do is create an analysis and a framework about that and work with Leonard on that, who is a joy to work with on, because he's known it all along and has been saying that. And he understood it right away and was excited about that. That part in developing not only that advocacy piece for Leonard, but as an impact issue for other people who are experiencing the same kind of thing from the U.S. Parole Commission was very important because it actually put Leonard in a place where the legal issues, the actual active legal issues, not necessarily 50-year-old ones or the ones having to do with trial, were front and center about the unlawfulness of Leonard's detention. And I could go into so many other things in which point to the unlawfulness of Leonard's detention. But I will say, if people want a rundown of this and an understanding, there's a United Nations working group on arbitrary detention report on Leonard that gets into this and as to why he's arbitrarily detained. That decision was not easily received because he had before been considered for arbitrary detention by that working group of the United Nations and did not receive it. But at the time when they really reviewed the malfunctioning of his case to that point, which was in 2022, it was obvious, and to them, and that he was being arbitrarily detained by the United States.
Okay, so with that incredibly clear explanation, so supporters have always maintained his innocence, and you touched on this in the opening, maintained his innocence, evidentiary and prosecutorial misconduct, evidence, a number of issues. That's on the wrongful conviction side. If I understand what you've just articulated, you've been talking about wrongful detention side. And one of the listeners asks, why did it take 50 years to free Leonard Peltier? And I was going to say, well, he was accused of killing 2 FBI agents and he's Native American. Those two, strike one, strike two.
Yes.
So with that, if you could answer that question.
Yes, I think that the Native American bias that has been covered extensively by domestic civil rights and movement organizations, as well as international bodies who are devoted to the human rights of all people who have noted that there's absolutely Native American bias that affected Leonard, not only his prosecution, but his continued detention. It has taken so long because the political and legal waters haven't necessarily been welcoming or in a position to effectuate Leonard's release. I think over the course of time, there have been people who have come in and out of the case with certainly the best of intentions and have done wonderful things and wonderful work. But I think politically, it's been near impossible until the current political moment. And then I think legally, the case law has developed such that it's ripe for the kind of challenge that we needed to make and to raise those legal issues. So I hope that's clear, but it's an amalgam of racial bias, political bias, First Amendment issues, political will or ability to effectuate his release, which has not worked, as everyone knows, the past decades, and then also the development of case law.
So again, looking at the number of holes that were in the prosecution's case, and those holes over the years have been identified at various times, but it seems at every turn the judges would say, yes, there was prosecutorial misconduct, but we're not going to let him out. Yes, there were evidentiary problems, but we're not going to grant a new trial, or we're not going to let him out. It seems as though as many holes that were identified, almost like looking at a piece of Swiss cheese, they'd say, yes, this is Swiss cheese, but we're not going to make the sandwich. We're not going to let him out. Is that a valid question to ask? Is that a valid point to raise?
I think that is a valid question. Yes, I do. I think the law and justice are two different things. And what you're referencing is the courts having noted that there was prosecutorial misconduct, that there were evidentiary issues and things like that, but nonetheless saying that it was harmless, what we call harmless error. And, that is a long-standing doctrine and part of the analysis and a post-conviction analysis that still continues today. Last year before last, the Supreme Court decided Jones versus Hendricks, which makes it harder for innocent people to receive post-conviction relief, and in fact, it bars it for many prisoners. In fact, and Justice Ketanji Brown Jackson's dissent, if anyone is interested in reading that, really breaks down how it operates to keep people in prison. Post-conviction relief, it has always been very narrowly construed and really reflects, as much as I love my profession and I love my work, reflects the arrogance of our system and not wanting to recognize biases or even just simply mistakes. I mean, think about what happens in death penalty cases, and the of course, a lot of times it's motivated by bloodthirst, but just the absolute refusal sometimes to consider new evidence, that even when the prosecutor comes back and says you should not, execute someone, there is still a refusal to overturn that decision. And so we've got to get rid of that arrogance. We've got to extricate that from our legal system. And we also need to really look at the biases that can be baked in a really in a meaningful way, because yes, Leonard had been there incarcerated for way too long and should have never been incarcerated, but his prolonged incarceration really reflects the judicial system and the legal system's distaste for reversing these kinds of decisions.
And Des Ehrlich, thank you so much for your super sticker. Greatly appreciate that support. You know, this, in listening to you, this just popped into my mind when you talked about the reluctance for post-conviction relief.
Yes.
Is the fact that the prosecution was never able to identify another culprit factor into this? Because I can imagine the prosecutor saying, well, you know what? Or the judges saying, you know what? Yeah, maybe there was prosecutorial misconduct. Yeah, there were evidentiary problems, but there are 2 dead FBI agents and we don't have anybody else to pin it on. So since we got him here, we're going to keep him here because we can't let these deaths go unavenged.
Right. I think colloquially, a lot of people have felt that this case was very much a vindication for those officers' deaths, and that there was an attitude that any quote unquote Indian will do, and that they need to pin this on someone. Of course, Kellyn Raleigh has stated in the past about the vendetta that the FBI has against Leonard, and I can attest. I saw this certainly during the parole hearing of the things that were written and said about Leonard by Christopher Wray himself, the former FBI director. It was quite shocking, and it was clear to me that there was a commitment to continue to still characterize Leonard as a cold-blooded killer, despite the evidence.
In fact, I believe Christopher Wray not only made that reference, but also referred to him as unrepentant. And
Yes.
But if you did not commit the crime, and if you didn't commit the crime, and there's all of this evidence of prosecutorial misconduct, then it's not he's unrepentant. He continues to articulate his innocence.
Right, and our argument about that is that doesn't mean that Leonard is dangerous, does not accept responsibility, is untruthful, and in fact, it points to the fact that he's quite truthful to have held on to his innocence for this long. If he wanted to be dishonest and just try and get out, and say what they wanted to hear, he could do that, but he did not, which tends to show that he's honest, obviously not dangerous, and should have been released a long time ago.
Without rehashing history, and honestly, I would really need to sit back and go back through my memory banks. Pine Ridge, what were the FBI doing on the sovereign state of the reservation in the first place that led to the confrontation?
We're told that they were trying to serve someone a warrant.
Okay.
Yeah.
That's what I thought.
Yeah.
That's what I thought. And that this thing just quickly, again, and I think it's important for people to understand that the Pine Ridge Reservation is sovereign Indian territory.
Yes.
It is a separate nation. It is a separate state.
Yes, it is. It is. Those are tribal lands that are sovereign to the folks who live on Pine Ridge, many of whom are Lakota. And yeah, of course, many people have argued they shouldn't have been on there, on the reservation like that, and they likely shouldn't. But it all happens within the reign of terror, in which the people in and around the reservation were being terrorized with all kinds of brutalities at the time, and so it was a cultural and political clash. And the folks there who were on their sovereign tribal lands felt a need to protect themselves and that they were being occupied by the federal government.
Where does the case of Leonard Peltier fit in the pantheon or in the broader spectrum of American political prisoners, especially when we can talk about Imam Jamil Al-Amin, we can talk about Mumia Abu Jamal, Assata Shakur, who refers to herself as an ex-political prisoner because she's now living in exile in Cuba. I would still put her in the political prisoner category because her liberty is limited by the action of the government. But I don't know if you want to elaborate on that. But your thoughts on this whole idea of American political prisoners, especially in the context of so many references when the United States wants to talk about other leaders of other governments. They want to talk about authoritarians, and they want to talk about dictators, and they want to categorize or vilify folks whose governments they don't really appreciate, totally ignoring if we've got political prisoners in this country, authoritarianism would probably be an apt reference.
No, absolutely. I think Leonard's case and what has happened with him as a political prisoner falls directly within the anti-colonial struggle. It is emblematic in many ways of that. And I think this case is often rightfully told through the lens of the American Indian movement and Native American rights, but in my view, it ultimately should and must be understood more broadly within the anti-colonial struggle. Similar events have happened globally in South Africa, in Palestine, for example, all around the world. The shanty towns and the Soweto uprisings and the South African apartheid are to Pine Ridge, and the incident on Jumping Bull and the Reign of Terror and removal policies and ghettos are to Jim Crow to Gaza. Mandela's unfair trial and decades-long incarceration are to Leonard and Imam Jamil's unfair trial and decades-long incarceration. They all bear the same characteristics by way of colonialism and the repression that is part and parcel to that.
Another thing that just popped into my mind around this, and especially as we were talking about Imam Jamil Al-Amin, we had some representatives of his case on the show a while ago. And one of the points I made then was, and for those that may not know or remember who Imam Jamil Al-Amin is, you would probably remember him as H. Rap Brown, former member of the Black Panther Party for Self-Defense, who's incarcerated now, and about the same age as Leonard. I would say they're
a year apart.
They're a year apart. Is that in talking about Imam Jamil? Once the government got their sights set on him, as with so many others, they're not going to let you go. And the irony here is, after 50 years of being incarcerated, the U.S. government finally did not let Mr. Peltier go, but released him from physical incarceration in a penitentiary to home confinement.
No, I think that's absolutely true. One of the things that strikes me in working with political prisoners, including Leonard, and I don't represent the Imam, but in knowing his story and how personally he has impacted me as a Black movement lawyer. And then, of course, Leonard is understanding the essence of who these men were and why the government, it becomes very clear when you meet or speak with them or engage with their work, why the government had such a objective to suppress and repress their presence in the community. The work that the Imam was doing in the West Side, to disrupt that. Obviously, that was a threat to the government. He has been almost, just a part of the soundtrack of Black Power in this country and around the world. And moved to the spiritual element of things, and that was still just as powerful. The same thing with Leonard, also bears that spiritual characteristic and that strength as a sun dancer, and how he has stood for his people, and he does it anytime, any place, whether that's in a hearing, whether that's in his sentencing statement from the 70s. If folks want to go and read, there's very little variance in what he says because he stands strong. And those are the kinds of freedom fighters that the government tends to target and want to repress.
And one of our listeners, Zhao Yun, writes, Leonard Peltier was basically a prisoner of war. Yes. And then writes, the right to armed resistance is protected by international law. And right. That is true. But the problem is that the United States, unfortunately, is not a signatory to a number of the international law courts / provisions. So the United States loves to invoke the term international law when it's to its benefit to do so, but will not be held accountable by international law, a la I don't remember the exact name of the act, but the government the United States government has passed a law saying they will invade The Hague. If an American official is put on trial, they will invade The Hague. So when you listen to people like Tony Blinken, he loves to talk about the rules-based order, which has no technical definition. But rarely will you hear them talk about international law. Thank you, the Hague Invasion Act. That's it. Unless it is to the rhetorical benefit to do so.
No, that's absolutely true. There are now the United States is a signatory on the Convention Against Torture, but not the Mandela rules on the treatment of prisoners, conveniently. And yes, they do use international law selectively. And I wish some of my other colleagues were on here to discuss more, but that's another. It is true, particularly in Leonard's circumstance, that he is a prisoner of war, and that gets into treaties and the Constitution and all of these other elements of pulling a little bit from international law, but that is actually exactly right. He's literally a prisoner of war.
Well, in fact, that's why I made the point earlier that the Pine Ridge Reservation was a sovereign nation. It is a sovereign space within the United States. Technically it is a sovereign entity, and so for the United States to go in the manner in which they have, or which they did, was in violation of those treaties, and very well. And so talk about, even though the United States is not a signatory to a number of these international tribunals, talk about the importance of internationalizing the struggle, internationalizing the argument.
No, I think it's very important, and we've revamped a lot of the international efforts in this past 2 or 3 years that we've been representing Leonard. We did submit a complaint on the Convention Against Torture to the Special Rapporteur on Torture of the United Nations, and also did some work with the Organization of American States as well. And that's because the way the conditions of Leonard's confinement, particularly at USP Coleman 1, were in violation, certainly of the Eighth Amendment's prohibition against cruel and unusual punishment, the incessant lockdowns, the medical neglect, all of the things that Leonard was going through while there rose to the level of a violation of the Convention Against Torture and also the Mandela Rules, right? But the United States is not a signatory on that. But just, the Mandela Rules are almost completely an opposite of the way prisoners are treated in the United States, and certainly federal prisoners. So we highlighted these lockdowns, which are a form of solitary confinement on the international level. The lockdowns, the 24/7 lockdowns that Leonard was experiencing, and in fact left out of USP Coleman 1 on lockdown. That's how persistent and prevalent they were. On Leonard's day of release, they were actually in a lockdown. They're ignoring and their failure to get him to a medical facility, even though he 79 years old at the time, on a walker, falling all over the place, relying, and we are grateful for it, relying on the help of other prisoners to not fall, or if fall, to get back up. Several hospitalizations, inconsistent diabetes, care. At times, there was a time where Leonard was shackled, in the shower in his walker, which really, obviously, myself and co-counsel Maura Meltzer-Cohen took quite an issue with that and worked that out, where he could, not be shackled anymore. But it was getting to a fever pitch, particularly since they would not grant any of our requests for an emergency medical transfer, so Leonard could get the care that he needs. So what we did, or what I did, was I added to our legal team a couple of doctors and a psychotherapist who would visit Leonard at least on a monthly basis, especially the doctor who was right there in Florida, so that we could get an independent account of how he was doing while we, continued to fight the battle with him. It's also so Leonard could feel seen and encouraged and empowered by a visit from a doctor, to be able to disclose his symptoms and what was really going on without fear of any kind of retaliation, which is really important, which the BOP has had a long-standing history of as well against Leonard. So those are the sorts of things that we did in terms of, that we highlighted in terms of the international law piece.
I just want to read this quickly so people can fully grasp the hypocrisy here. The Hague Invasion Act is the euphemism or the informal nickname for what is actually called the American Service Members Protection Act of 2002. And this law allows the United States to use force to free U.S. or allied personnel from the International Criminal Court, which is, by the way, folks, is not in Cleveland. It's not in Wyoming. It's in The Hague. So the United States is saying that they can, under all intents and purposes, invade another country if a U.S. If a U.S. person or allied personnel is taken to the International Criminal Court. So I want folks to understand the hypocrisy and the arrogance in all of that. And as we move to close, because I know you've squeezed us in here. You've mentioned Mr. Peltier being on a walker, being basically infirmed. He's 80 years old. Imam Jamil Al-Amin, 81 years old. This takes us to the aging, the problem with mass incarceration and the aging of our incarcerated population.
Absolutely, it is death by incarceration is what that is, and I believe that it's by design to cripple the spirits of many of our elderly prisoners, whether they're political prisoners or not. But certainly our political prisoners, these are dignified men, and it is an attempt to strip them of their dignity. So while, of course, you go through all the things and all the mechanisms and remedies for release, you have to be able to work with a client who can stand in their dignity and help you win their case. So it was one of, other than the constitutional violations, the first things that I did to be able to stabilize the case, because I wasn't going to let them crush my client. And so I think it's very important at this day and time to think about our elderly and aging prisoners, especially, many are baby boomers. It's the largest population, so there's a lot. And as I look down the road on the day of the release, and I saw, I'm not sure if there's many pictures of it. There may be some, maybe one of our comrades on the team has it. But I looked down the road, and there were, on rolling walkers, just like Leonard's, other elders who were standing with him in solidarity. And I thought, well, that's not keyboard courage, that's conviction. And Leonard has held that conviction. And but that just goes to show you that's who they're incarcerating now. They insist that they continue to incarcerate them as these elders on their walkers, and all kinds of medical issues, and who should be home. So yes, please, if there's a way for you to support any local organization, national organization that is doing work on these issues. Federal old law prisoners. Leonard is an old law prisoner. Dr. Mutulu Shakur is an old or was an old law prisoners, and many more, which the United States government has not kept good track of. There's about 123, 150, and to please write them, support them, donate to their support campaigns, because many of them are unlawfully held for a myriad of reasons, just like Leonard. And many of our political prisoners who are federal prisoners are within that class. So is William Dunn, political prisoner, as well. So I can go on about aging in prison, but it is a form of death by incarceration.
Death by incarceration. Oh, wow. Attorney Jenipher Jones, thank you so much for your work. Thank you for your perseverance. Please let Mr. Peltier know that, as I know he knows, but I'm sure he can never get tired of hearing how many people out here support him, love him, and are so glad that at least he is now at home and no longer confined in an American penitentiary.
Thank you, Dr. Leon, for having me on. Thank you for your support of Leonard, and thank you to all of you who are listening for your support of Leonard. Keep uplifting him. It's as I say, it's his day in the sun in which there is no dusk. And so thank you for all your support.
Can I ask just one more question?
Oh, sure.
Okay. So he is at home. Technically, he is still in confinement. So is he able to receive visitors? How, within the confines of that restriction, that home detention, how much freedom does he have?
He is at home and he's allowed to have visitors. There are conditions, of course, about the number of people and getting a pass for certain things, whether that's legal visits or what have you. But the good news is that he doesn't have an ankle monitor or any kind of electronic monitor. He seems to be able, at least this one weekend, to do what he needs to do. Family able to access him, in a good way and on a frequent basis, consistently.
Okay. Well, we of course continue to pray for his health, the improvement of his health, and again, Attorney Jones, thank you, and look forward to having you back.
I look forward to speaking with you again. Thank you again for having me.
My pleasure. My pleasure. So thank you, Jenipher. So, folks, there are a couple other things that I quickly wanted to hit on, and this is ironic, if not just insane. This is from the Washington Post. Supreme Court seems poised to lower the bar for whites to sue for job bias. This is the Washington Post headline. Supreme Court seems poised to lower bar for whites to sue for job bias. The Supreme Court today appeared to support the idea of making it easier for men and women who are white or straight to sue for job discrimination. The High Court's conservative supermajority and at least some of the liberal justices seemed receptive to arguments by Marlene Ames, who's challenging rulings by many of the nation's courts that require members of majority groups to meet a higher standard to prove job discrimination than groups that have traditionally faced bias. Folks, if that's not insane, the justices appeared ready to strike down the test. Both conservative and liberal justices peppered in the Ohio Solicitor General over the state's opposition to Ames' arguments, pushing him to eventually affirm that he too thought minorities and members of majority groups should be treated equally. We are in radical agreement. So basically, Ames, a straight white woman, filed a job discrimination lawsuit after she was removed from her job, as at the Ohio government agency overseeing juvenile. She said she was unfairly passed over for other management roles, which went to women who she considered to be less qualified. It's I'm not going to get into all those gory details, but that's interesting that now the court seems interested in lowering a standard so that white people and straight white people will be able to make easier claim of discrimination. That is interesting, to say the least. Let me also throw this out. One of the things that we hear as Elon Musk and his Doge commandos are rampaging through the government, trying to shut down agencies and fire people. And we talked about this yesterday with Dr. Jim Kavanaugh, is the fact that they say that the government is too large and that the government it costs too much, so that they've got to go in and they've got to chop heads in order for them to get the budget under control. But here's some interesting data. And this is data. The government employs, and depending on how you define government employee, let's just say 2.5 million people. 2.5 million people. It might be closer to 2 million if you look at just direct government employees and you don't include contractors. So let's say direct government employees, 2 million. the size of the government has not dramatically increased since the 1960s. And that's not opinion, that's not hyperbole, that's fact. The cost of government employee and the cost of government employment as a budgetary line item is about 6% of the budget of a $1 trillion budget. 6% of a $1 trillion budget. That's not a lot of money, relatively speaking. That's not a very large budgetary line item. And we know, for example, in the private sector, labor is one of the largest or highest costs of operating a business is labor. That's why, to a great degree, the United States deindustrialized so much of its industrial capacity overseas in search of cheap labor. So again, if you look at the United States budget, direct government employees, about 2 million people, 6% of the budget. I would think if the mission were truly to reduce costs, there are nine, if I do my math right, 100 minus 6 is 94. There are 94%, there's 94% other costs in the budget that you could turn to if you were serious about reducing cost. And I would submit to you that the military expenditures are a lot more than 6%. So if Donald Trump were being honest, which we know is a true challenge for the man, if Elon Musk were being honest, which we know is a true challenge for the man, going after employees would not be the first place you would go to reduce costs. Now, Elon Musk, as a private sector business owner, I understand that mindset because I just said on the private sector, that's where an overwhelming amount of your costs go as it relates to production is labor. But when you look at the government, that's not the case. It's another reason why you can't manage the government in the similar manner that you manage the private sector, because its cost structures are different. And you damn sure can't do it efficiently and effectively. If you are trying to increase government efficiency, if you are trying to improve government effectiveness, one would think you need to be efficient and effective in your pursuits. And this Doge commando raid is anything but efficient, is anything but effective. They've gone into the operating room and replaced the scalpels with bludgeons and meat axes. It just doesn't make sense. So when Donald Trump sits behind the Resolute desk or stands at a podium and says, we created Doge, Department of Government Efficiency, to make the government more efficient, Wrong answer. When Elon Musk says we're doing this to lower costs, no, you're not. You're being incredibly opportunistic. You are being intellectually dishonest. You are, in fact, being inefficient, because look at how much all this is going to actually cost at the end of the day through these lawsuits. By indiscriminately removing employees who are actually effective in what they're doing, you, over the long term, are going to make these processes even more expensive. You say, Mr. President, you love the veterans, and that you've said, you didn't use the word sacrosanct, because I don't think you know what the word would mean, but you have said over time that, you have to, one of your primary objectives is to take care of the veterans. So what do? You remove employees from the Department of Veteran Affairs, which was already understaffed, which was already underfunded. But you increase the workload on those remaining employees, so you make them less efficient. You make them less effective. You make life more difficult. You make the veterans' quest for service even harder to acquire. So, folks, they're lying to you. They're just flat. All of this really centers around trying to carve out space so that Donald Trump can get his hand deeper into the till. Still, this is actually a kleptocracy. You can look that one up. This is a kleptocracy. Donald Trump is stealing from the American coffers, from your tax dollars. This is thievery. And Elon Musk is complicit in the crime. I'm not making that up. And note to Hakeem Jeffries, who's asking what would we expect him to do? Hakeem, why don't you say to the American people what I just said? How about that as something to do, since you can't figure out what to do? You're befuddled, you're confused, I don't know what to do. Well, why don't you explain to the American people what I just explained, and use the facts that I'm using? And again, folks, facts, data, that's why Larry calls me Dr. Data. Why don't you do that, since you're looking for something to do? It is called a kleptocracy. That is where government officials steal money. That's just an idea. All right. With that, give me 1 second here to here's what I want to do. So with all of that, I want to thank you all for joining me today, for listening to the show. Thank you, and stay tuned. New episode tomorrow. Professor Nikolai Petro is going to be my guest, and you are going to get quite a lesson on the truth about what's really going on in Ukraine and why. Professor Nikolai Petro is going to be our guest tomorrow. Stay tuned. Again, new episode tomorrow. Petro is going to join us. Please follow and subscribe. Leave a review. Share the show. You can find us on social media. Find all the links below in the show description. Remember, that Patreon account really needs your support. And those of you that haven't clicked the like button, please, please, please do so. All of those things, for as trivial as they may seem, we're trying to get to 10,000 viewers, 10,000 likes. And I just need you, even if you can't make a contribution, please, before we get out of here today, click the like button. That will help raise revenue for the program as well. Again, follow us on social media. You can find all the links below in the show description. And remember that this is where the analysis of politics, culture, and history converge, because talk without analysis is just chatter. And we don't chatter here on Connecting the Dots. See y'all tomorrow. Until then, I am Dr. Wilmer Leon. Have a great remainder of your day. Peace and blessings. I'm out.
Connecting the Dots with Dr. Wilmer Leon, where the analysis of politics, culture, and history converge.